the first information report and subsequent investigation, if required, had come to its logical conclusion, stop. As pointed out here before, there are several other factors, that will have to be considered before it can be said that the proceedings, which were born out of the first information report, had come to an end, whereafter no further action, on the same cause of action was warranted, stop. In Sanjay Bhagat's case, Supra, with Mr. Kleshwar Prasad Singh, learned Syrian counsel, relied upon, the judgment of this court, contrary to the present case, did not have to deal with a situation, wherein a charge sheet, under section 173 bracket 2 of the code, had been filed, but the magistrate had not taken cognizance, rather, the magistrate, in the present case, issued notice to the informant and conducted an inquiry under the mechanism provided in the code, before taking cognizance of the offences, on the ground that in terms of the charge sheet, all the accused, named in the first information report, had not been sent up for trial, bracket. See law laid down in Bhagwant Singh's case, bracket Supra, bracket close, stop. It is also pertinent to note that in Sanjay Bhagat, bracket Supra, the developments of this court did not have the opportunity to consider the decision of the Supreme Court in Jeevan Kumar Raut, bracket Supra, Suresh Kumar Bhikam Chand Jain, bracket Supra, and Rathin Dhanpat, bracket Supra, stop. Even in Pavan Kumar Jaiswal, bracket Supra, and Iskela, bracket Supra, the court had not been dealing with the situations, which we are to deal with in the present case, stop. In the present case, because of the fact that the notice, in the light of the law discussed in Bhagwant Singh's case, bracket Supra, was required to be sent dash and was, indeed, sent dash to the informant on the ground that the charge sheet had not been submitted against all the accused persons named in the first information report, there was delay in taking cognizance, stop. This court in Pavan Kumar Jaiswal, bracket Supra, and Iskela, bracket Supra, did not also have the occasion to take into consideration the decisions in Suresh Kumar Bhikam Chand Jain, bracket Supra, Jeevan Kumar Raut, bracket Supra, and Rathin Dhanpat's case, bracket Supra, stop. It is an undisputed fact that in the present case, the magistrate had, at the material time, not exhausted the process of hearing the informant and passing necessary orders as to whether the final report, not sending up for trial all the accused, are named in the first information report by the informant, ought are to be accepted or not, stop. In the case at hand, the magistrate took time in conducting the inquiry as to whether the decision of the investigating officer not to send up, for trial, some of the accused, named in the first information report, was correct or not, stop. For the time taken by the magistrate in conducting such an inquiry, the accused dash petitioner, against whom charge sheet has been filed, within the stipulated period of 90 days, cannot claim that his custody is illegal for being in contravention of the provisions of the code, stop. The conclusion, reached above, can be tested from yet another angle based on the doctrine of implied powers stop. In the case of Sakri Basu versus State of UP, reported in 2008 SCC 409, the Supreme Court held that it is well settled that when a power is given to an authority to do something, it includes such incidental or implied powers, which would ensure the proper doing of that thing. Stop. In other words, when any power is expressly granted by the statute, that is impliedly included in the grant, even without a special mention, every power and every control, the denial of which would render the grant itself ineffective. Stop. Thus, where an act confers jurisdiction, it impliedly also grants the power of doing all such acts or employ such means as are essentially necessary for its execution. Stop. The reason for the rule, popularly known as the doctrine of implied power, is quite apparent. Stop. Many matters of minor details are omitted from legislation. Stop. As Kra Board observes in its statutory construction. Stop. If these details could not be inserted by implication, the drafting of legislation would be an interminable process and the legislative intent would likely be defeated by a not insignificant omission. Stop. In ascertaining a necessary implication, the court simply determines the legislative will and makes it effective. Stop. What is necessarily implied is as much part of the statute as if it were specifically written therein. Stop. An express grant of statutory powers carries with it, by necessary application, the authority to use all reasonable means to make such grant effective. Stop. Thus, in ITO versus MK Muhammad Khuni, the Supreme Court held that the income tax appellate tribunal has implied powers in grant a stay, although no such power has been expressly granted to it by the Income Tax Act. Stop. In Savitri versus Govind Singh Rawat, reported, the Supreme Court held that the power conferred on the magistrate, under section 125 of the code to grant maintenance to the wife, implies the power to grant interim maintenance during the pendency of the proceeding, otherwise, she may starve during this period. Stop. This position of law, on granting of interim maintenance, was enunciated before section 125 of the code was given the present shape, making interim maintenance explicitly a statutory right. Stop. There is another aspect of the matter, which hits the maintainability of the case. Stop. The petitioner has, admittedly, been in custody pursuant to the orders passed by the court. Stop. The challenge, in this writ petition, has been made, primarily, on the ground of the jurisdiction of the magistrate to pass remand orders after filing of charge sheet, but before taking cognizance. Stop. The offences, which the accused person is alleged to have committed in the present case, are serious in nature. Stop. No doubt, on merits of the case, the right of the accused to be granted bail is available to him, but the mere fact that a final report, under section 169 of the code, has been laid against the accused would not ipso facto entitle the present accused petitioner to claim an indefeasible right of bail or to be released from custody. stop para.